Hello and welcome to the March 2021 episode of My PIP Monthly. My name is Amber Rouse Holloway and I'm a partner here at Secrets Wardle at our Troy office. Our March 2021 topics include, of course, a case law update. First, we will discuss the unpublished opinion of Michigan Spine and Brain Surgeons, PLLC, v. Citizens Insurance Company of the Midwest. And next, we will discuss Jawad A. Shah, MD, doing business as Insight Healing Center, v. State Farm Mutual Automobile Insurance Company. That opinion is also unpublished. And then next, for trending topics in PIP litigation, we'll discuss injured parties and balance billing. Michigan Spine and Brain Surgeons, v. Citizens Insurance Company of the Midwest, an unpublished opinion as I indicated earlier. Essentially, in this case, the Michigan Court of Appeals affirmed that a PIP medical provider with an assignment of rights executed by a PIP claimant lacks standing to bring the claim against the insurer after an arbitration agreement or a dismissal with prejudice is entered into between the underlying parties. By way of background, this lawsuit arose out of a motor vehicle accident that occurred in September of 2015. At that time, the insured, a William Ford II, was injured and subsequently filed a claim for no-fault benefits with the MACP. That case was then assigned to Citizens Insurance Company. On May 8, 2018, Ford and Citizens entered into an arbitration agreement for all claims for PIP benefits, past, present, and forever into the future, and dismissed the underlying litigation with prejudice. The arbitration agreement contained an anti-assignment clause which provided that Ford could not assign any no-fault benefits included in the arbitration and would also indemnify and hold harmless Citizens for any medical bills that were assigned. On November 9, 2019, of course, after entering into the ARB agreement, Ford underwent surgery at plaintiff's facility, Michigan Spine and Brain Surgeons, and then assigned to Michigan Spine and Brain Surgeons his right to payment from Citizens Insurance Company. After that, plaintiff made a claim to Citizens for payment, which was, of course, rejected, and then this lawsuit was filed, and Citizens moved for summary disposition. Ultimately, the trial court granted Citizens' motion and concluded that without a valid assignment, plaintiff lacked standing to sue Citizens. Thereafter, the Court of Appeals agreed and noted that in the context of no-fault law, a healthcare provider who obtains an assignment from an insured possesses whatever right the insured would have to collect past due or presently due benefits from the insurer and no more. The court reasoned that when Ford assigned to Michigan Spine and Brain his right to payment by Citizens for his surgery, he had already agreed to submit all claims for PIP benefits that stem from the accident to a neutral arbitrator and had stipulated to the dismissal of the lawsuit against Citizens with prejudice. Therefore, at the time Ford assigned his right to payment to PIP benefits to Michigan Spine and Brain, he had no right to assert the legal action against Citizens for those claims and could not assign any more rights than he already possessed. As such, the Court of Appeals held that the trial court did not err by holding that plaintiff did not have standing to assert a claim by Citizens for payment of PIP benefits for medical care rendered to Mr. Ford, and the ruling was affirmed. Next up, we have the case of Jawad A. Shah, doing business as Insight Healing Center, v. State Farm Mutual Automobile Insurance Company. This is also an unpublished opinion. This case gives guidance into how courts interpret statutes and laws, as well as how they give deference to administrative agencies in their decision. In this case, the Court of Appeals essentially explained that they typically defer to an agency's expertise on making a judgment concerning an agency's decision. They expressed that the decision of the Department of Licensing and Regulatory Affairs was entitled to respectful consideration from the court in this case. As such, it's important to note that the Court of Appeals will not likely stray from an agency's interpretation and conclusions of law unless there is evidence that requires them to do so. Here, the Michigan Court of Appeals held that services plaintiff billed for were lawfully rendered and compensable under the No-Fault Act, as plaintiff's facility did not qualify as an adult foster care that required a license. By way of background, In Insight, Michael Stone was an individual who was struck by a vehicle insured by defendant State Farm. He was subsequently admitted to Plaintiff Insight Healing Center for rehabilitation and therapy from 2016 to 2018. In 2014, after receiving complaints that the facility was operating illegally, the Department of Licensing and Regulatory Affairs visited Plaintiff's location for an investigation. After the investigation, the department concluded that Plaintiff was not an adult foster care facility and therefore did not require a license. Defendant still declined to pay the outstanding $787,000 bill as they disagreed with the department's findings. Ultimately, defendant State Farm argued that Plaintiff was not properly licensed and was operating illegally at the time of the service. The trial court agreed and concluded that the services provided by Plaintiff were not lawfully rendered and were therefore not compensable. Plaintiff then appealed, and it's important to note that in the court's analysis on appeal, it focused on the statutory definition of adult foster care. Michigan's Adult Foster Care Licensing Act, or AFCLA, provides the regulations and standards for adult foster care facilities. At the time of the service, the AFCLA defined foster care as the provision of supervision, personal care, and protection in addition to room and board for 24 hours a day, 5 or more days a week, and for 2 or more consecutive weeks for compensation. The discrepancy between the parties focused on the meaning of the provision of. Plaintiff's position was that it did not provide Mr. Stone with any supervision, personal care, or room and board. Any individuals that did assist Mr. Stone were independent contractors who had no relationship to Plaintiff. Plaintiff also argued that residents were permitted to select their own providers and that it was not their responsibility to direct the type of care received. The defense conversely argued that even facilitating or arranging the provision of services required that the facility be licensed. The court examined the phrase of the provision of and interpreted it based upon the facts in this case. Expanding on this, the court explained that the licensing should have been required only if the establishment itself was providing supervision and care. Plaintiff deliberately distanced itself from providing any of those services, and there was no evidence to suggest that that was done improperly. Again, the AFCLA defined foster care as the provision of supervision, personal care, and protection in addition to room and board for 24 hours a day, 5 or more days per week for 2 consecutive weeks for compensation. The court also noted that this issue was properly vetted by the Department of Licensing and Regulatory Affairs. The investigator explicitly stated that because there is separation between the entity which owns the property and the entity providing the direct care services to residents, the facility does not fall under the authority of the Licensing Act and therefore does not require a license. The Court of Appeals agreed, stating that in general, they give deference to administrative agencies unless there is a legitimate reason to overrule them. They concluded that there was no evidence that would give them any reason to disagree with both the department's interpretation of the statute and conclusion that plaintiff did not require a license. As such, there was no evidence of unreasonable and unnecessary billing in this case, and they reversed and remanded the trial court's decision. Today, I wanted to discuss injured parties and balance billing. Generally speaking, this is a case of a plaintiff that is an injured person, so not a provider suit or a medical facility, that is attempting to claim balance billing as a part of their outstanding medical benefits in their PIP claim. And balance billing typically occurs when an insurance provider pays a portion of the bill due to reasonable and customary rates, and there is a balance left over that the facility is still attempting to claim. Insureds are directed by the Commissioner of Insurance to defend and indemnify their insureds. The 1992 interpretive statement issued by the Commissioner of Insurance requires that insurers provide insureds and claimants with complete protection from economic loss for benefits provided under personal protection insurance. Automobiles insurers must act at all times to ensure that the insured or claimant is not exposed to, harassed, dunning, disparagement, or credit or lawsuit as a result of a dispute between a healthcare provider and an insurer. Essentially, insurers are not obligated to pay for balance billing under the No Fault Act, including but not limited to billing unreasonable amounts for services rendered, upcoding, and billing for services unrelated to the motor vehicle accident. So that's essentially how balance billing occurs. Insurance companies review the bills, and it is determined that what is left over after payment of the insurance company is either an unreasonable amount for services rendered, upcoding, or billing for services that were unrelated to the subject accident. In insurance contracts, insurers typically agree to indemnify plaintiffs or the injured parties and offer protection from economic loss from providers. As we all know, under MCL 500-3171A, personal protection benefits are payable for allowable expenses consisting of all reasonable charges incurred for reasonably necessary products, services, and accommodations for the injured person's care, recovery, or rehabilitation. As such, the injured party/plaintiff has not incurred those charges from providers. As the defendant, the insurer has assumed responsibility for the defense of the potential claimants. The Court of Appeals in the McGill v. Auto Association case addressed this very issue and found that plaintiffs were sufficiently protected when the defendant expressly stated that it would indemnify and defend plaintiffs in the event that plaintiffs were sued by the providers for the outstanding balance or the balance bill. The McGill opinion also reaffirmed the Lamothe v. Auto Club Association opinion when the Michigan Court of Appeals held that notwithstanding the fact that refusing to pay unreasonable medical expenses is allowed under the insurance contract, in an effort to hold the insured harmless should the healthcare provider sue the insured has agreed to fully defend and indemnify the insured from liability for necessary services provided in excess that the insurer considers to be reasonable and customary. Essentially, what this is saying, my interpretation of what this is saying is the provider does not come after the underlying insured, the injured party, for that balance bill, and therefore those charges are not incurred by the plaintiff or the injured party. And if the provider would come after the plaintiff or the injured party, then the insurance company would defend and indemnify that party. Of course, this requires that the insurance contract have a hold harmless agreement, which most of them do, but it must be a sufficient hold harmless agreement for this argument to be brought up in a motion for summary disposition. Such, a plaintiff has not suffered any pecuniary injury by way of medical provider invoices because they have not been incurred by the plaintiff, and thus the plaintiff has failed to create a genuine issue of material fact on those issues. As such, a motion for summary disposition, if you have this specific set of facts, is appropriate. My personal experience with these type of motions has been fairly successful, but again, this is a specific case of a plaintiff attempting to claim balance billing, not a provider on its own, a provider suit claiming the balance billing. Generally, when I file motions such as these, I outline the bills being claimed and attach as exhibits the invoices for the bills that I am claiming are balance bills. And the invoices, you should be able to see that the insurer made payments. After a result of those payments, there is still a remaining balance. On the other side of the coin, plaintiffs have argued. I've seen a few things. I've seen plaintiff highlight each bill and say that it is unknown or not clear that it is actually a balance bill. If you attach bills that do not show that the insurer made payments, then it does appear that it is not a balance bill. So it is important to do that. I've also seen plaintiffs argue that pursuant to the case of Williams v. AAA Michigan, that a plaintiff's submission of medical bills is enough to constitute reasonable proof of a charge being incurred. If that's the case, then all the plaintiff has to do is submit these bills and they've incurred those charges. Obviously, the McGill opinion states the exact opposite, that just because they are submitted does not mean the entire amount is incurred by the plaintiff him or herself. Ultimately, I believe filing motions such as this one with this specific set of facts is beneficial to the defense and should be done when applicable. And that is all for the March 2021 episode of My PIP Monthly. Again, my name is Amber Rouse Holloway. Thank you for listening. Please feel free to contact us with any questions or concerns or comments you may have. Thank you.